I think we're probably good to go. All right, so welcome everybody to this MCEA webinar. This is one in a series of webinars that we're doing for our supporters and our donors. And today we want to take some time to give you an inside look at one of our cases, a case that took us all the way to the US Supreme Court. We also just want to say thank you to you, especially if you're one of our sustaining donors. Those are the folks who give monthly. Those monthly contributions are especially important to us now as we navigate what will undoubtedly be some rocky times ahead. And so thanks for that commitment. We can't do this work without you, and we really appreciate it. I am Kevin Reuther. I'm MCEA's Chief Legal Officer. And with me today is Nancy Schuldt. Nancy is the Water Projects Coordinator for the Fond du Lac Band of Lake Superior, Chippewa. Hi, Nancy.
Hello.
Thanks so much for taking the time to be with us today. And then also with me is Elise Larson. Elise is our Senior Water Attorney. Hi, Elise.
Hi, Kevin.
So what we have planned for you today is about 30 minutes. We'll try to respect your time. We thought that we'd spend about the first 20 minutes describing this case that we had at the US Supreme Court, where we were an amicus party, and why it's important for Minnesota. And then we wanted to reserve at least 10 minutes for your questions. And you'll see at the bottom of your screen, I think it's at the bottom of your screen, a little box that says Q&A. If you want to put questions in there, those will pop up and I'll be able to see them and we can respond to them towards the end of our presentation today. So I think that we'll start with just kind of giving some background about the case, the Maui County case. Elise, do you want to kick us off there?
Yeah, so the County of Maui case has to do with a wastewater treatment system in the County of Maui in Hawaii that puts its wastewater into 4 what are called injection wells. So they're wells that go down into the ground and into the groundwater. And those 4 wells discharge approximately 4 million gallons a day of wastewater into the groundwater. The groundwater in this particular location is about a half mile from the Pacific Ocean. And so what really teed off this case was that they started to see effects in the Pacific Ocean just off the shore of where this discharge was happening to the groundwater from these wells. And they were seeing environmental harm. And so some environmental groups from Hawaii brought this case under the Clean Water Act to try to require some restrictions on that 4 million gallons a day of discharge that was hurting the Pacific Ocean.
So just to clarify, the pollution was going into the groundwater and then migrating into the ocean and affecting the coral, the fish population, that sort of thing.
Correct.
And I remember that one of the interesting things about this case is that it wasn't just the environmental groups, but it was EPA, the federal government, had done a tracer study, I think, where they put some dye into the discharge and they could actually track how the pollutants were getting into the ocean.
Yeah, so after the lawsuit was filed, the EPA under the Obama administration did the tracer study, and they came to the conclusion that this was a discharge. Even though it went to the groundwater first, it was so connected, the pollution getting into the ocean was so connected that this would need to have a permit under the Clean Water Act. But that was ultimately reversed by the Trump administration. And when we were at the Supreme Court, the Trump administration was there representing the opposite position, that because this was in the groundwater, it didn't really matter that it was having any kind of environmental effect on the Pacific Ocean.
So it might be surprising to folks that aren't environmental lawyers that the Clean Water Act doesn't really include a permitting requirement for direct discharges to groundwater. So the Clean Water Act says that you have to get a permit if you're going to discharge into navigable water, which has been interpreted to mean waters where you can navigate, but also connected waters to those navigable waters. So pretty much all of the surface waters that you can think of, rivers, streams, wetlands, lakes, and the ocean are what is protected by the Clean Water Act. And this permit requirement typically does not attach to a discharge to a groundwater. Maybe you can say a little bit about the theory of the case. So why should they have to have a permit here?
Yeah, so for a long time, 40 years, the position of the EPA was that even if you had pollution that was going into the groundwater first, if the groundwater had what was hydrologically connected or a direct hydrologic connection, that you still needed to get a permit. And the idea was that the Clean Water Act is intended to protect navigable waters. And when the groundwater is so connected to the surface water, the only way that you can protect it under the Clean Water Act is to regulate those discharges. Here, the County of Maui disagreed that they needed to get a permit, and they took the position at the court that essentially, unless that well was going right into the surface water, or what's most often used is a pipe, unless you had a pipe going from the polluter into the surface water, you didn't need to get a permit, which is really dangerous because it would make it really easy for polluters to avoid needing to get a Clean Water Act permit. All you need to do is take that pipe away from the surface water and have it cross the land, have it go in the groundwater, maybe even have it go through the air. And that makes it so that you don't have to comply with all of the requirements and protections that the Clean Water Act brings.
Great, thanks. So one question folks might have is why we at the Minnesota Center for Environmental Advocacy and the Fond du Lac Band would have an interest in the case out of Hawaii. It turns out that this issue is really important for Minnesotans, and it appears in many of our mining cases because the huge tailings basins where the waste from the mines are stored, they leak into the groundwater, and that then affects the surface water. So I'm wondering, Nancy, if you could kind of describe for us a little bit more of what I just said, I guess, and talk a little bit about the Minntac case as an example.
Sure, I'd be happy to. I've often referred to the Minntac facility as the poster child for the tribe's awakening to the impacts of mining in Minnesota to tribal resources, both reservation resources in the case of Fond du Lac, as we lie downstream, our reservation waters are downstream of many of these facilities, but also within the ceded territories to which the tribe retains hunting, fishing, gathering rights. We learned back in about 2004, 2005 that Minntac, through an EIS for changing their water management, they had been using and recycling the pool, the effluent in the tailings basin back into their processing. And it was becoming so concentrated with these dissolved pollutants, including sulfate, that it was beginning to corrode their equipment. And so they were looking for a way to not have to use their own polluted water in their own processing. And they were proposing to just simply siphon that polluted water off into the West Twin, which is a direct tributary to the St. Louis River upstream of the reservation. And as we investigated and really dug into this EIS and prepared comments and looked at the information that was being provided, we came to recognize that an assumption that we had for many years, that the MPCA was in fact enforcing that wild rice sulfate standard of 10 parts per million, was not in fact the case. We know that just off to the right side, the east side of that tailings basin, Little Sandy Lake and Sandy Lake and the Sand River are wild rice waters. And they had essentially been wiped out because the permitted release of pollutants. They have an NPDES permit that is actually allowing them to release and discharge their polluted tailings basin effluent to these waters untreated. Over time had actually diminished and degraded and eventually extirpated the wild rice downstream. So although there's connection to the groundwater, these tailings basins are actually constructed and sit in wetlands or in headwaters regions. So there's that connection to the groundwater, but those seeps are also discharging directly to surface waters. And so the pollution is getting rapidly to adjacent surface waters.
You can see in this map, so I mean, the big eye in the center there is the tailings basin where all of the polluted water is stored, and that keeps getting recycled and the pollution concentration gets higher and higher, as Nancy described. But you can see from the map that it's sitting right on the headwaters of those two rivers extending to the east and the west from it. So the hydrologic connection that Elise is talking about is very real and clear when it comes to this particular example. And that's why it was really important for us as Minnesotans to make sure that the Supreme Court at least heard from us, and we wanted to make sure that we made our arguments to them so that they could get this case right. So maybe, Elise, you could describe a little bit about what role we played. I mean, we weren't the main party. Obviously, the main parties were from Hawaii. How did we get in front of explain how we got in front of the Supreme Court on this, or the Fond du Lac Band?
Yeah, so when the Supreme Court takes big cases like this, you have an opportunity to file what's called an amicus brief or a friend of the court brief. And really, the reason the Supreme Court likes these briefs is they're making decisions that don't just impact the one case, this County of Maui case and these particular wells, but they're making a decision that's going to affect lots of projects and lots of people around the country. And so what we were able to do in this Friends of the Court brief is explain to the Supreme Court what the implications of deciding in favor of the county or deciding in favor of the environmental groups, what impact that would have on the band and the band's rights to harvest wild rice, as well as the health and well-being of members of the band.
And Nancy, maybe you can talk a little bit about why, from your perspective, it was important for the court to hear from the tribe.
So again, we had focused on this facility, but in the meantime began to look at how all of these mining facilities were being regulated. And then the EIS process for Polymet opened up, and of course they're proposing to use a leaky old taconite tailings basin to handle their mine waste.
So same kind of thing for Polymet.
Exactly. And so our concern lies with the way the MPCA was not interpreting their responsibility under NPDES permitting. In fact, these tailings basins have permits that have been expired in some cases for decades, and they don't have any applicable permit limits that relate back to those important water quality standards, including the wild rice sulfate standard. And we had been pushing and pushing on the agency, on EPA and their oversight capacity to improve these permits, to actually protect the resources that they're intended to protect. And we could see that the state was not moving in that direction. And of course, when this came in front of the Supreme Court, we knew that any hope we have of seeing better permits being written and enforced in the state of Minnesota are really going to hinge on what the Supreme Court says today.
Yeah. And that's really what these cases are about, is better permits. I feel like, I'm sure that many of our donors and supporters who are listening today have been following the news and have seen, you know, what came out of the IRRB in the last few days about the Fond du Lac band and the request for assistance from the IRRB for water infrastructure. I'm just wondering if you have any response to that you'd like to share.
Yeah, it's kind of touchy, but I would say that the band has always been very clear that our engagement in reviewing permits, in being involved in environmental impact studies, has not been with the intent of shutting down mining. That has never been the focus. We have always been involved to the extent that we are with the idea that we are going to protect to the greatest extent possible the resources that are guaranteed under the treaties. And we're also interested in seeing that pollution is actually controlled and abated as it is supposed to be under the Clean Water Act. That's our primary goal. It's not to stop mining, it's to stop pollution.
Yeah, and we at MCA share that. You know, we're anti-pollution, not anti-mining. We say that all the time. So it's been great to have this partnership with you all at the band and to be able to work on this and other cases together. Let's see. Elise and I actually had the opportunity to go and witness this oral argument, which was super interesting and really fun. I don't know, Elise, do you want to just say a highlight from your trip to DC?
Yeah, I mean, Kevin and I really lucked out. So to watch a Supreme Court argument, if you are, you know, a lawyer in the case, you get to go to a shorter line, but still quite a long line, and you get to show up at 5 a.m. And Kevin and I
And it was still quite cold then, I would say.
It was November, November in DC, so not November in Minnesota, but still not particularly warm. But Kevin and I got sat right in the front row. You know, we were feet away from Justice Kavanaugh, who ended up, you know, being a really pivotal voice in this case, siding on the side of protecting the environment. And it was incredible. I guess the one big thing or the very exciting moment, I think, for both Kevin and I was after we watched the oral argument, we were out on the steps talking with the lawyers in the case. And I just want to share one picture.
This was my highlight.
Oh, this was yours? I'm sorry. But we got to meet and talk to Nina Totenberg from National Public Radio about the case, which was just a really cool opportunity to talk to her as she, you know, follows all of these cases so closely and knows the justices like the back of her hand. So that was great.
That was pretty fun afterwards to be there on that sunny, beautiful day. And as it turned out, the Supreme Court rejected the Trump administration's arguments, and they sided with us. So Elise, maybe you want to describe sort of the outcome of the decision.
Yeah, so the court was kind of faced with these two, you know, whether there can be groundwater or whether groundwater going into surface water can count or not, were kind of the two sides that they were faced with. And they kind of came to a compromise position, recognizing that it would be a huge exception to the Clean Water Act to take the Trump administration's view that it has to be a pipe directly into the water. And so the test that they came up with is if it's the functional equivalent of a discharge to surface water. And so in the case of this County of Maui case, a half-mile EPA had done all of these tracer tests that really connected this pollution from the well to the Pacific Ocean. That was a case where you would need to get a NPDES permit. And obviously, this is a mushy test, and there's going to have to be a lot of case law development about what that test means. But considering, you know, the alternative was that going to create this huge exception to the Clean Water Act, this was really a win for the environment. It was a huge win.
And Nancy, maybe you can talk a little bit about what importance the win has for advocacy here, particularly maybe about Minntac. I mean, there's been so much litigation, and how will this impact the situation on the ground at Minntac?
Well, All I can say is like what Elise just mentioned. It's certainly good that we got this decision out of the Supreme Court rather than what a lot of us were kind of afraid we were going to see. As you know, we have challenged the reissuance, the very late reissuance of the NPDES permit for the Minntac tailings basin. And because this case was pending in front of the Supreme Court, the Minnesota courts put a pause on any of the appeals that have come out. Originally, the Minnesota Court of Appeals had sided largely with the challengers, the tribe and MCEA and other environmental groups, to the original reissuance of the NPDES permit for Minntac, agreeing with us that MPCA needs to do a better job of looking at what the potential is for pollution and impacts to downstream waters. It wasn't a real clear directive to put limits in your permit, but essentially telling them that they needed to do a better job. And so the company and MPCA appealed that. And so having that resolved hinged upon this determination coming from the Supreme Court. And I think it sets up the future determinations for what happens with the Minntac NPDES permit to our advantage.
Yeah, I would definitely agree with that. I'm seeing some questions come in, and everybody, you should feel free to ask your questions in the Q&A at the bottom of your screen. One is from Bob Tamman, who's asking about whether the science is settled on the tailings ponds groundwater connection to surface waters, or whether we will also have to do these kind of tracer studies. Do you have a sense for that, Nancy?
I think we have really strong evidence. Some of it has been submitted through previous briefs and proceedings, and certainly in endless comment letters over the years. I think the company's own studies that they've been required to do over the years, as they've been given a lot of time to just study this problem and not really fix it. I think there's a long trail of evidence that is going to make it really difficult for U.S. Steel to say with a straight face that there's no hydrologic connection.
Yeah. There's really no other source of these pollutants up there.
That's true.
Here's a question about whether the participation of the band made a difference for the case. Would it have been the same without Native participation? Elise, maybe you can talk a little bit about the role of amici in these kinds of cases. Elise clerked for a year or two at our Minnesota Supreme Court, so I'm sure that you've seen a lot of amicus briefs. How did the justices react to them?
Yeah, in my experience, amicus briefs are helpful to thinking through. Justices look at amicus briefs to think through what the long-term implications of their decision might be. And so while, you know, we don't actually know what happened in the justices' chambers, I think that we can fairly assume that the justices read our brief and used it in realizing that adopting the Trump administration's test really would be, you know, harmful to the band's interests. Another interesting thing about our brief that I think probably was helpful to the court is one of the main arguments was that there were all these other laws that would be protective. And we were really able to show, with using wild rice as an example, why statutes outside the Clean Water Act just are not adequate to protect that resource. And I think that that was probably a very persuasive example to undermine the idea that the Clean Water Act isn't really needed to be protective.
So another question here about sort of the impact of the decision on permits, both for Minntac, but then also for PolyMet and the process of how the permitting agency, which is the MPCA in Minnesota, will have to deal with this decision, which is really interesting. Elise, you've been working on the Polymet NPDES case. By the way, Nancy referred a couple times to NPDES, and I think we probably said NPDES. That's just the permit that is required by the Clean Water Act. Environmental people use a lot of acronyms, so apologies for that. But maybe Elise, you can just give the, a short version of what's going on with the water permit and in Polymet and how this will impact that.
Yeah, so it'll be very interesting. The water permit still has not been heard by the Minnesota Court of Appeals, and so we haven't really had an opportunity to brief these issues. And now that the Supreme Court has decided this case, I think that it's going to present different arguments than we would have probably presented before this case was issued. The position of Polymet is that they're going to put in a system where even though they are polluting the groundwater, which they admit, that they're going to catch all of that pollution and they're going to put it back into the basin. I think that there is quite a bit of evidence that these capture systems are not nearly as effective as Polymet is claiming that they are. And I think that the company and the PCA would admit, because the current LTV basin is leaking into the groundwater and ending up in surface water, that if these capture systems are not effective, this is going to be a discharge into the groundwater that reaches surface water. So for the purpose of Polymet, it's really going to, I think there's going to be sort of the legal issue, because the company admits that some pollution is going to get past this system, and whether that meets this new hydrologic connection test. And it's also going to be a factual question of whether the company and the PCA have really shown that these capture systems are going to operate the way that they say that they are.
And, this decision, it applies now to every Clean Water Act permit. And so we're sort of focused on Polymet because that one is in litigation now and was just issued, but there are a number of permits that the PCA is probably going to need to take a second look at to see whether or not they need to be amended. And it's something that we at MCEA will be on the lookout for as well. It's kind of an interesting question, how broadly the decision will affect these permits that are out there and existing now. So question about the IRRB denial, can there be a legal challenge to it? What we're really focused on right now is trying to put pressure on the administration to make sure that they don't take the recommendation of the board. So right now what the board did was offer a recommendation. The commissioner and the administration can give grants as they see fit. They don't have to follow that recommendation. I think the last news, and Nancy, correct me if I'm wrong, but the board is going to be meeting again next week?
I believe so.
And we have, we issued an action alert, which all of you hopefully received over the email, and hopefully you responded to it. I know that there were over 1,000 emails and tweets that went into both the commissioner of the IRRB and Governor Walz's office from our action alert. And so I know that they're feeling the pressure. If you did send an email, you got a response from the commissioner himself saying that they're going to be taking this up again. So we're pretty hopeful that the politics of this are going to lead to a good outcome and that we won't have to sue anybody, but to be determined. Let's see, I see that actually our time is up. And so I think in order to respect everybody's time, we should probably sign off. I just want to say again, thank you all for supporting MCEA. I think that, we cannot do this work without you. It's not cheap for us to file a brief with the US Supreme Court or pursue any of this other litigation. And so we really depend on your donations and we're grateful for that. One last thing, I guess this is being recorded, and I believe tomorrow it will be sent out in an email. You should receive it if you want to share it with friends or others who couldn't make it today. So thanks for being here, and enjoy the rest of your day. Bye-bye.